I'm coming on today to fill you all in on the latest developments. We have yet another appeal against our activities at Bubble Grove. Activities that were established back in 1983. We are a recognized existing use business with NEC and Ontario Land Tribunal decisions to uphold that fact. We have documentation that outlines the use, as well as including that camping and outside short-term accommodations and alternative structures was an ongoing use established by the previous owners. We have that from witness statements and from statements from the previous owner himself, including in an affidavit that was written for the appellants against us, making a very clear statement that he in fact did start camping on site as part of his retreat center activities. So when we had another appeal come against us that put those activities into question, we said, based on what? And we have asked the Ontario Land Tribunal to require the appellants to put forward any evidence that they have that would go against our use, or point to any direct error in how policy was applied in offering in confirming the proposal that we've put forward. We provided in our motion to dismiss a pretty thorough overview of policy and legislation, as well as case history, that from our reading were quite clear that the onus is on the appellants to provide evidence at the time that the appeal is put forward, and that this is how we qualify whether or not the appeal is legitimate and valid and worthy of the adjudication process. To give you a little bit of an insight, you pay for all of it. Ontario Land Tribunal is a publicly funded process, so these are expensive. This takes a lot of steps. This isn't just a one-day thing. It is a serious business, as is mine. My serious business has been held in limbo for years, and it should, not only is it the cost involved in providing these services that is put on the taxpayer, but also the limbo and holdup that is caused to the landowner and business who is put in this very uncomfortable position. This costs all of us, and it costs time and energy that could be put towards other activities that are more beneficial for, ourselves, for our community, for Ontario in general. So it is very concerning that the Ontario Land Tribunal, instead of choosing to follow the path laid out by the policies and the case authority that says that the onus is on the appellant to earn their right to appeal by showing that they have either direct evidence of negative impact in the past or to be caused by the proposal, or to point to some sort of error in how policy was applied. And if they can't do that, if they can't show that they have evidence or that somebody screwed up somewhere, then what exactly was the appeal supposed to achieve? The Ontario Land Tribunal isn't just a second opinion. It is not a place that you're supposed to be able to just say, well, I don't like that decision and I want you to rethink it. The qualifications are that the Ontario Land Tribunal is there to solve a challenge against an error or negative impact. And if neither of those two things can be shown, then there's no trial to go forward. And dismissals have been put forward on these qualifications time and time again. For some reason, in this situation, even as an existing use with 40 years of history, at 4.5 years in on this conversation, to have a thoughtful, eco-forward, adaptive reuse to a legacy commercial endeavor confirmed. My gosh. Even then, the Ontario Land Tribunal has chosen instead to set a very dangerous precedent that appellants do not need to provide any basis for their case before a trial is granted. Even at a motion to dismiss, they are not required to present any evidence or any direct policy error, and they can just make vague promises that they'll have it someday. So, This is of concern, and I hope that you help share this forward and help get the word out about what's happening to us and to other businesses like us.